5 seconds to go. Start. Mr. Puran Saxena, a law graduate but not practicing as an advocate, has preferred the present petition claiming to be an unemployed youth and engaged in doing social work for the upliftment of Sikkim. There are no details of the social works the petitioner has been doing in the past. The petitioner claims that after his graduation, when he came back to Sikkim in the year 2013, he observed that there was no overall development in the state and the money received from the center had not been utilized in the proper place for the upliftment of the downtrodden people of Sikkim. There is no further clarification to this broad spectrum allegation. It is his plea that whenever he would visit remote areas, he would notice poor people staying in deplorable condition and thus was anxious to find out the exact reason as to why, despite the central government providing funds to the people of Sikkim, have not been proportionately uplifted. Besides the allegation, there are no facts pleaded or proof submitted to substantiate the allegations. The petitioner claims that he started doing research in the matter and came across shortcomings in the functioning of the governmental machineries. The petitioner claims that those shortcomings were that the funds were utilized on non productive schemes, there was no proper allocation of funds to such schemes which would directly benefit the downtrodden. The funds were provided for religious matters, funds were not provided for construction of roads, electricity, establishments of specialized hospitals, schools, research work, technical education, medical facilities, etc., which are the basic requirements of the people. There is not a single document filed with the writ petition to substantiate the statements made about the petitioner's perceptions of the said shortcomings. It is claimed by the petitioner that while doing research, the petitioner came across one notice inviting tender published in the newspapers. The petitioner therefore sought for copy of the NIT under the Right to Information Act 2005 and the petitioner was furnished with copy of the NIT published in the newspapers. On a perusal of the NIT, the petitioner claims that he was shocked to notice that the publication of the NIT was done in a casual manner. The petitioner claims that the publication of the tender has not been done in widely circulated papers insofar as the petitioner's knowledge goes, but also states that the publication shows that it was published in e-tender. It is the perception of the petitioner that only a handful of contractors are conversant with computer knowledge. Yet another grievance of the petitioner is that the tender does not disclose the nature of work and schedule of work. Petitioner could not point out any such non-compliance from the records of the case. The petitioner states that he also received one corrigendum dated 5th July 2017 through the process of the Right to Information Act 2005. The petitioner claims that on examining the invitation for bids dated 23rd May 2017, the petitioner came to learn how public money from the government exchequer had been embezzled. Stop.